Well, good afternoon, ladies and gentlemen, and welcome to today's Knowledge Group webcast on AML and CTF, taking a look at some trends, developments, and enforcement actions to guide companies in 2021, where my name is Andy McLeod. I'll be your moderator for this afternoon's program. We're going to hand things over to our speakers in a brief moment. Just want to quickly point out over the next few slides, you will see some information about the mechanics of our event, information about our participants and their respective firms. In terms of the website, that's a great way to view the certificates you've earned, continuing education requirements, and much more. It's all there on your account portal, and you can find that on the go as well with our Knowledge Group app, available for both iOS and for Android. Now, finally, everyone will be sent a brief survey via email after the conclusion of this presentation. But if you are applying for continuing education credit this afternoon, that survey is mandatory. It serves as your proof of attendance. I'll be reading 3 secret words at random times that you'll need to make a note of and enter them into that survey as proof of attendance. Before we begin this afternoon, I want to take a brief moment to thank this afternoon's sponsor, LexisNexis Risk Solutions, and our partner firms, Nyman Gibson Morales, as well as Murphy and McGonigal. Their information is on screen now. I'd also like to extend our thanks to our speakers for their time, help, and support in preparation for this afternoon's program. So without further ado, we'll introduce this afternoon's speakers. Tracy Manning is leading us off this afternoon, a director of the Financial Crime Compliance over at LexisNexis Risk Solutions, where Tracy is a digital identity and financial crime expert with over 25 years of experience driving data strategy, innovation, and growth efforts within companies like AT&T, Cox, Twitter, Cincinnati Bell, as well as Ground Truth and K2View. And she now leads strategy development and product innovation planning for the North American financial crimes compliance market at LexisNexis Risk Solutions. We're also going to be joined by Dennis Morales, a partner at Nyman Gibson and Morales. And Dennis is a leading Australian defense lawyer who acts and advises on complex domestic and international crime law matters in some of the following areas. We've got international money laundering, as well as white collar and corporate crime, serious fraud, cyber crime, international asset forfeiture, as well as international proceeds of crime law, bribery and corruption law, as well as transnational crime, extradition law, mutual assistance in criminal law matters, as well as anti-terrorism law, national security law, criminal intelligence, and encryption law as well. And he appears in all courts throughout Australia and regularly travels outside of Australia for complex international and transnational criminal law matters. Eric Bensky is our final speaker this afternoon, a shareholder at Murphy and McGonigal, where Eric focuses on securities litigation and enforcement with an emphasis on representing prime brokers as well as clearing firms and other broker dealers in court, arbitration, and regulatory investigations, as well as disciplinary proceedings. And over the past several years, he's represented broker dealers and their personnel in regulatory examinations, as well as investigations and enforcement proceedings concerning anti-money laundering obligations, and particularly with respect to the monitoring, investigation, and reporting of potentially suspicious activity. Now, non-broker dealer clients have included a leading national and international bank, as well as a major mutual fund complex, public companies and their officers, as well as their directors, individuals and entities suspected of or charged with insider trading, as well as investment advisory firms and hedge funds as well. Now, speakers, to advance the slides, just say next slide at the end of each page of your presentation. We'll take care of the rest. Before we do turn things over to Tracy leading us off this afternoon, just wanted to give the first of today's 3 secret words, where secret word number 1 is fraud. That's F-R-A-U-D. So secret word number 1 of 3 is fraud. But for now, we're turning our attention to slide number 11 on screen now. And Tracy, whenever you're ready, over to you.
Absolutely. Thank you, everyone, for joining today. So we can't really talk about trends today without really talking about the pandemic. And obviously, the pandemic has produced a number of key trends in the area of compliance, some of which have been surprises, others maybe not so much. But one that I think every organization and every consumer is feeling without a doubt is the acceleration of digital transformation. So we've been watching the acceleration of digital transformation for some time, but as we moved into shutdowns and the attempts to socially distance. COVID-19 just really pressed the fast forward button on that. And it forced even the greatest resistors of technology to become adopters almost overnight. Analysts in recent polls would say that this is a hard trend. In other words, it's one that will not completely reverse, even as we move away from mask wearing and can move back towards life as we knew it pre-pandemic. So if you move on to the next slide for me, even pre-COVID, digital now was representing a majority of transactions, fundamentally changing the way that companies transact with buyers, suppliers, vendors. The vast majority of transactions and interactions are now digital, projected to reach about $4.4 million worth this year. And as mentioned, this is not likely going to be moving backwards. So business transactions have dramatically changed, but the way that businesses are managing risk against all that has really not changed with it. It has not kept pace with that change. And so in a time when elegant, frictionless digital experience is now a strategic imperative, this is a pretty thorny challenge that I think COVID really has helped us have to face even a lot sooner than we may have reckoned previously. So on to the next slide. As we moved into the pandemic, LexisNexis Risk Solutions really wanted to try to have a handle on what was going on. So we began sort of compiling a lot of our own internal data sources so we could look at what the signal was telling us. And this is one such look at our proprietary data from within our digital identity network. And we've seen that this trend that we're talking about has really been confirmed throughout the pandemic. So in the months after the onset of COVID, we're seeing new devices transacting for the first time ever on our digital identity network, up 24%, even in August, right? Compared to that baseline of January, February, pre-pandemic. So on to the next slide for me. And financial criminals are very much capitalizing on this acceleration in a very big way. They're hiding behind these faceless transactions and among all these transactions that are being conducted from new devices by legitimate customers to mask their activities and avoid detection. So, just as an example, hackers are now attacking every 39 seconds, on average 2,244 times a day. And we see, 68% of business leaders feeling cybersecurity risks are increasing. We see, breaches are even increasing just even in recent days, right? Look at the breach on the federal government over the past day or two in the US. And so this is definitely a trend that is coming along with all the good things about digital transformation. Next slide for me. And to add to this perfect storm, regulatory scrutiny is also shifting swiftly, and it's soaring, particularly when it comes to places where it maybe hadn't in the past, like e-commerce and technology, and even things like energy companies, right? Enormous hidden risk lie in financial institutions and in corporate sanction programs. Global penalties totaled $36 billion for noncompliance with AMC, KYC, and sanctions violations in December 2019. And amid global trade tensions, sanctions violations make up almost 40% of the 2019 fines. And then, of course, you've got FinCEN and the Undersecretary of Treasury for Terrorism and Financing Intelligence issuing, simultaneous statements at the end of 2018 that was encouraging FIs to innovate with new technologies to stymie illicit threats. So even in recent days, again, just go to the news from the past week or two, we're seeing this activity ramp up, right? Look at the actions that were announced against Facebook, et cetera. Lots going on here in this space. And some folks who haven't been used to having a lot of regulatory scrutiny, finding themselves in a position where they're likely going to have to be used to a lot more for the foreseeable future. So next slide for me. Most notably, though, we see sanctions risk increasing for corporates, so for non-banks, right? And of 26 OFAC penalties in 2019 that totaled more than 1.2 billion, 57% involved organizations that were not financial institutions. So in the first 7 months of 2020, all 7 OFAC penalties and 81% of fines levied were aimed at organizations that are not financial institutions. So this includes a February 2020 OFAC penalty of a non-bank that totaled more than 7.8 million, and a U.S. technology company that was penalized for violations of the OFAC 50% rule. Next slide. So in another piece of proprietary research, our true cost of financial crime compliance study, we keep tabs at LexisNexis on the true cost of compliance year over year. We uncovered several very impactful trends in our study this year that are specifically linked to the pandemic that we wanted to share today. But feel free to visit our website if you're interested in picking up a full copy of the study, which dives into a whole lot of other areas we didn't have time for. First, respondents identified their top 3 compliance challenges. First was difficulty accessing KYC or due diligence sources, with 42% saying they were facing difficulty in that area. Next would be challenges tied to delayed onboarding of accounts. 41% said they're struggling with this. And of course, tied to that is longer times to complete due diligence for onboarding new accounts, of which 38% said they were experiencing delay on that. And as I think most of us have seen, consumer patience with these kinds of delays is not improving. Customers now know what a seamless, elegant experience looks like, and they expect it from all of us. Next slide. Our study has shown also that COVID-related acceleration of digital transformation has also greatly impacted compliance effectiveness and efficiency. A staggering 90% reported a negative impact on customer risk profiling, 83% on sanction screening, 78% on KYC for account onboarding, and then 74% on efficient resolution of alerts. Next slide. And unfortunately, like digital transformation, our survey respondents feel these impacts are far from over. 79% expect that COVID will continue to impact financial crime compliance costs for the next 12 to 24 months, with about 68% of that increased cost going towards technology resources and 32% going to labor resources. Next slide. So based on these trends, we thought it would make sense then to take a deeper dive into one specific area, and that is sanctions risk, and how it can potentially be reduced in this era of accelerated digital transformation through the use of digital identity intelligence, which is a technology that's been used quite a bit in the fraud space in recent years, but hasn't necessarily been extended into things like sanctions risk. Next slide for me. So this is an area where, in particular, we're seeing a situation in which traditional solutions, the way we've always done it, are just not meeting the challenge. So, traditionally, solutions have largely been manual versus automated, retroactive versus real time, primarily based on physical identity versus a blend of physical and digital intelligence. And then they often create friction in the customer experience that just leads to a lot of frustration, even amongst your most loyal customers. Next slide. So here's why digital identity intelligence is a solution who we believe is a solution whose time has actually come. So first off, think of it this way, and we all know this very well, bad actors don't use their real name when filling out applications online. So as a result, name matching against sanctions lists is often inaccurate, it's manual and inefficient. Alert volumes continue to grow each year, and the average time it takes an analyst to clear a sanction alert is 4 hours. And based on our most recent True Cost of Compliance survey, only growing, right? In this time of COVID. Analysts are overwhelmed. 52% of financial institutions say half a week of lost productivity occurs per FTE analyst due to job dissatisfaction. So the frustration of the inefficiencies of kind of trying to trying to assess the risk associated with these largely digital transactions in the same way that we've always been doing it in the past for more physical transactions is really palpable at this point. And so bottom line, companies stand a grave chance of erroneously defaulting on regulations worldwide, of receiving high dollar fines, and receiving public censure through headline grabbing news if we don't do something different. Next slide. So enter digital identity intelligence. I'm just going to give you this one snapshot that is from our digital identity network of just 1 day of transactions in potential risk jurisdictions, right? So this is the percentage of them that were using a proxy. I think if you were to learn, right, that you had a large number of transactions coming from North Korea who were also using a proxy, that would be something that you would probably all be very, very concerned about, or from any of these areas for that matter. Next slide. And so I wanted to show you that just to kind of pique your interest around the kinds of things that digital identity can do. But what I want to talk about first is why, what's not working is currently pretty clear, right? So currently companies are either blocking IP addresses from comprehensively, from jurisdictions, or screening against global watch lists and monitoring for PEPs, right? And so, a lot of people think of, even blocking IP address as, hey, I'm using digital identity intelligence. Not really. That's not really what we're talking about here. And we're going to get into what we are talking about in just a moment. But what they're not leveraging is the intelligence on digital activities and the identities behind them. So in other words, that digital exhaust that any user kind of leaves behind them across the ecosystem as they transverse it. And that's whether they're a good customer or a bad customer. So a trusted entity or an untrusted entity. Next slide for me, please. So there's a strong case to be made that digital identity intelligence is actually the key to overcoming all this madness. So it's really the missing link, we believe, in your sanction screening program. And it's the key to alleviating a lot of these frustrations of lost productivity, manual tasks, and high analyst turnover. It was singled out as an opportunity to identify hazards. And it's the next generation fortress in sanctions compliance, and really just offers a very key competitive advantage to early adopters. Next slide for me. So through shared intelligence, like the power of a digital identity network, basically you can do a lot of different things here, right? You can reveal patterns, connections, transactions, and devices to deliver insights that are driven by a unified picture of identity. And so not one that's just based on device, right? Because obviously the bad guys use lots of different devices as well. I'm talking about a network where every time someone has transacted online, no matter from what device, no matter using what email address, right? All those linkages are formed across a very vast ecosystem to help basically judge the trustworthiness of a transaction based on all the past behavior associated with its various elements. So it can help you harness intelligence related to devices, to locations, and particularly true location. So proxy piercing technology can be used to determine where that transaction is most likely truly coming from. And then, of course, identities and past behaviors. And that helps you distinguish then between those trusted and potentially suspicious users in milliseconds, right? All in real time, right in the moment. So this allows you to then leverage a multi-layered risk assessment analysis process that's completely invisible to the user. And it benefits from the crowdsourced intelligence that comes from aggregating more than 30 billion global transactions annually. Next slide for me, please. So with all of that, I want to just pose a few questions to get you guys thinking a little bit more. in this digital space and in terms of being creative. So first, are you collecting and exploiting device and IP info routinely? Have you talked with your fraud experts to see what tools and data they use? Because they're using a lot of great tools that may have application for you in the compliance world as well. Are you comparing customer digital behaviors with your KYC info? Do you block online interactions from certain jurisdictions? A lot of you probably say yes to that, but here's the trick question. Do you monitor what they do next? Would you find it concerning if multiple geographically disparate digital identities accessed the same account nearly contemporaneously? Do you routinely compare the digital identities involved in suspicious transactions and behaviors with your broader customer or transactional base? And then last, have you ever checked to see which identities are accessing a PEP's account? Which digital identities are accessing that account? These questions are literally the tip of the iceberg when it comes to digital identity. Next slide. So bottom line is, there's a lot of potential when it comes to digital identity in terms of more effectively and efficiently managing e-commerce financial crime compliance risk. In near real time and using automated workflows, you can leverage digital identity, and it could be likely that your fraud counterparts are already using it. You can do this simultaneous with fraud screening, right? In real time, in the moment, and using passive crowdsourced intelligence that unmasks criminals without driving up false positives, without increasing manual workloads, and without creating undue friction for good, trusted customers. That's all I have for today.
Thank you so much. Thank you so much, Tracy. Before we do hand things over to our next speaker, to Dennis, just wanted to give our second secret word of the afternoon, where money is secret word number 2. That's M-O-N-E-Y. So money is our second of today's 3 secret words. Once again, thank you for leading us off, Tracy, but we're turning our attention now to slide number 29. Dennis, over to you.
Good afternoon, everyone, and thank you for attending today. In this segment, I'll be talking about anti-money laundering in the Asia-Pacific region, including recent trends, development and enforcement activity. My topic will cover 3 broad categories. Firstly, I will outline the anti-money laundering framework that applies in the APAC region, including the key regulators and law enforcement agencies. Secondly, I will focus on recent anti-money laundering law criminal typologies across the APAC region, including COVID-related matters, and then turn the spotlight onto the Fintel Alliance and the Joint Chief of Global Tax Enforcement, otherwise known as the J5, and examine what they've recently been up to. And finally, I will do a deep dive into some very recent and significant enforcement activity against Australia's largest banks for systemic and large-scale breaches against the AML laws, leading to record fines, including looking at the underlying offending. Next slide, please. So what is the APAC region? The APAC region, or Asia-Pacific region, encompasses a wide range of varying jurisdictions and states, including, amongst others, Australia and New Zealand, broadly known as Oceania, Vietnam, Thailand, Malaysia, Singapore, and in Indonesia, known as Southeast Asia, India and Pakistan, known as the subcontinent, China, Hong Kong, and Japan, Eastern Asia, the USA and Canada, and numerous Pacific Island nations. Money laundering occurs between multiple APAC jurisdictions as well as across the globe. Next slide, please. So how is AML overseen in the APAC region? Perhaps preeminently, the Asia-Pacific Group on Money Laundering needs to be mentioned. It's the Associate Financial Action Task Force member for the Asia-Pacific region. It has 41 member jurisdictions, and Australia is a permanent co-chair. The APG monitors member country compliance with implementing the international standards against money laundering set out in the recommendations of the FATF. In addition to that, Australia and many other APAC countries are also signatories, importantly, to the United Nations Convention Against Transnational and Organised Crime, which requires each signatory to have implemented in its domestic legislation anti-money laundering rules and compliance requirements. In addition to those international organisations which frame the way in which AML is dealt with in the Asia Pacific region. The United Nations Office on Drug and Crime also supports anti-money laundering capabilities by facilitating collaboration with global bodies such as the FATF, as well as regional bodies, including the APG. Next slide, please. So if we then focus on the agencies on the ground that are tasked with investigating and enforcing breaches of anti-money laundering, importantly, we have a police-led organisation which cuts across the Asia-Pacific region, which is known by its acronym PTCN, otherwise the Pacific Transnational Crime Network. This is an organisation that consists of 25 transnational crime units from 17 Pacific Island countries, including Australia, New Zealand, Samoa, Fiji, and the Solomon Islands. And it's an intelligence-led organisation which seeks broadly to combat transnational crime, one of those typologies, of course, being money laundering. In addition to that, probably the most significant financial intelligence unit operating in the Asia-Pacific region would be the AUSTRAC, which is the Australian Transaction Reports and Analysis Centre. It's quite a robust organisation, and it has dual functions under Australian law as both Australia's Specialist Financial Intelligence Unit, NFIU, and Anti-Money Laundering and Counter Terrorism Regulator. It also, in the last few years, has demonstrated that it has significant capacity as an enforcer, and some of the enforcement activity that I'll take you to towards the end of the slides will demonstrate that. AUSTRAC's regulatory and investigative powers are set out under the AML CTF Act and the Financial Transactions Report Act, and presently, to demonstrate how active it is internationally, it has 93 memorandums of understanding with 93 other FIUs, and is very active in the sharing of information across borders in order to assist other states in the detection and enforcement of money laundering matters. Next slide, please. So, in addition to those regulatory bodies, we have the Australian Federal Police, which is Australia's national law enforcement policing body. It's tasked under Commonwealth criminal law to investigate and prosecute money laundering and terrorism financing offences. The Australian Federal Police, similar to AUSTRAC, has an internationalist approach and has many strong working relations with most law enforcement agencies across the APAC region. In addition to that, we have the Australian Criminal Intelligence Commission, the ACIC. This is somewhat a unique intelligence criminal organisation in that it's been mandated by the Australian government to combat serious organised crime, and it's been provided with special powers to perform that mandate, which includes collecting criminal intelligence from partner agencies, utilising coercive powers under the Australian Crime Commission Act 2002 to obtain information. Those powers include the ability to compel people to attend compulsory examinations and to make admissions which override the protections that would ordinarily apply, such as the right against self-incrimination. They are also very much involved in acquiring strategic intelligence to support decision-making, strategic targeting and policy development, and also implementing a national target management framework to guide law enforcement in establishing and sharing organised crime priorities and targets. The ACIC is generally embedded in most of the law enforcement agencies that work cooperatively across the globe in detecting significant international money laundering, and they often provide the intelligence framework in order to carry out target identification. A number of other multi-agency task force, which are also relevant in the Asia Pacific region, include the Serious Financial Crime Task Force, the Egmont Group, and the Fintel Alliance. Next slide, please. So a quick spotlight on the Fintel Alliance. This is somewhat of a unique body that commenced in Australia in 2017 and has since been looked at by other jurisdictions across the globe, seeing whether or not it's capable of adding something to the investigation and enforcement of anti-money laundering law. So far, it seems that other countries that have been looking at the model that's been put in place have found that it offers something that to date hasn't necessarily been explored to the extent that perhaps it should, and many other countries are now looking to similarly implement a model very similar to the Fintel Alliance. What it is fundamentally is a public-private partnership. It was launched in 2017. The partnership brings together government, intelligence, law enforcement agencies, and Australia's largest financial institutions and businesses to combat serious and organised crime. Perhaps the most significant aspect of the way in which the Fintel Alliance works is that these organisations are co-located with law enforcement, so they work out of the same building, and they are capable of conducting investigations in real time, having access to the data that's held by the banks, and such that working hand in glove, law enforcement is able to in real time access that data and identify specific targets. The Alliance focuses on crimes affecting the most vulnerable community members, the exploitation of government revenue, networked and complex financial crime, nationally significant task forces and campaigns, and responding to regional and community harms, technology and sophistication. Over the past year, unsurprisingly, there's also been a strong focus on the impact of the COVID-19 pandemic, which has led to a surge in money laundering and terrorism financing, as well as other crimes such as pandemic-themed scams. Next slide, please. So the major achievements throughout 2019 to 20 for the Fintel Alliance, including arresting offenders for serious crimes, including money laundering connected to scams, trading of illicit tobacco and importation of childlike sex dolls, raising $22 million of tax liabilities, hardening the Australian border to child sex offenders, resulting in 25 detections of child exploitation material and the arrest of over 10 individuals for child-related offending. This is a particular crime topology that's prevalent in the Southeast Asia Pacific region in particular, protecting Australians from criminal networks that are exploiting COVID-19, including by fraudulently claiming superannuation and government payments, as well as by providing 250 intelligence products to law enforcement and intelligence agencies, helping to detect and investigate a range of crimes. Next slide, please. So the APG, which I spoke about earlier, each year publishes a list of the most prominent crime typologies connected to money laundering, and the most recent publication, which was released only a few months ago, covering the typologies of 2020, has identified the following as being amongst the most prominent in the Asia Pacific region. And again, unsurprisingly, we'll see that there is a strong, heavy COVID-related element. So fundraising for fraudulent COVID-19 charities has been identified as one of the major ones, as well as fraudulent claims from pandemic response programs, online fraud related to COVID, scams related to medical treatment for COVID-19, and then we have perhaps some of the more common typologies which appear to make the entry into almost every year's typologies, including illegal Phoenix activity, identity theft, kaku smurfing, and exploitative practices in labour hire arrangements. Next slide, please. So focusing on a COVID-19 related money laundering case study, we have here a series of facts which demonstrates that compliance officers are very alive to the fact that there can be suspicious transactions which are very unique to the COVID situation, which require careful observation and reporting to AUSTRAC. Here we have a factual circumstance which identifies that during COVID restrictions in Australia, where beauty services were prohibited from operating, a bank had identified that in the period of a fortnight, a particular beauty services business, which was meant to be closed, had deposited approximately $22,600 cash into one of the business accounts at multiple branches. The owner of that account then subsequently conducted funds transfers to multiple third parties for the value of $1,300 per transfer. In addition to that, the account holder also had a second business account which received $40,000 in transfers over the 4 days. It appears that these funds were then transferred by the account holder to another person at another bank. It was suspected that the funds may have come from illegitimate sources and are being channeled through the business in an attempt to legitimize them. Clearly, the fact that this account would have not been or ought not to have been operating during a COVID restriction was a red flag, and an eagle-eyed compliance officer identified this for further investigation. It's likely that many such similar type instances of COVID-related money laundering instances will continue to be investigated as we move forward. Next slide, please. So I spoke earlier about the Joint Chiefs of Global Tax Enforcement. This is a reasonably new initiative. It comprises of a number of nation states coming together, including Australia, the United Kingdom, the United States, Canada, and the Netherlands, in order to share intelligence, build capability, and carry out criminal investigative operations across the globe. It was formed on the 1st of July 2018 in response to a call to action from the OECD for countries to do more to tackle the enablers of tax crime. Earlier this year, the J5 undertook an operation coordinated across all 5 countries to support investigations into an international financial institution located in Central America, believed to be facilitating offshore tax evasion. That investigation is ongoing and is probably one of the major focuses of Australia's law enforcement, a whole of government approach moving forward this year and into next year. And it also involves very strong assistance from each of the partner agencies that are part of the J5, and it's likely that there will be significant law enforcement activity, including the bringing of criminal charges and regulatory action, both with respect to individuals identified as promoting this particular financial institution for the purposes of tax evasion, as well as regulatory non-compliance with AML legislation. Next slide, please. Finally, I spoke earlier about AUSTRAC's increasing activity in relation to enforcement against financial institutions in Australia. There are 2 very significant cases which have shaped the way in which AUSTRAC seemingly is now beginning to flex its muscle as a very robust enforcer. The first relates to a regulatory action brought against Australia by AUSTRAC against Australia's largest bank, the Commonwealth Bank. This was an enforcement that occurred in 2018, and the agreement reached between AUSTRAC and the Commonwealth Bank of Australia for $700 million penalty at the time was a record imposition of a fine under AML CTF laws in Australia. Next slide, please. In that particular case, the Commonwealth Bank of Australia accepted that it failed to conduct appropriate AML CTF risk assessments. It failed to introduce appropriate controls to mitigate and manage MLTF risks. It failed to report suspicious matters on time or at all, involving transactions in the tens of millions of dollars. Next slide, please. Notwithstanding that very significant enforcement activity, it was quickly followed up by an even larger and more significant action against Westpac, which is Australia's second largest financial institution. That commenced on the 20th of November 2019, and it settled in October 2020. The fine that was approved by the federal court in that case was $1.3 billion as a penalty for very, very large scale and systematic breaches of the AML legislation. In that particular case, Westpac Bank accepted that it had contravened the AML CTF Act on over 23 million occasions, exposing Australia's financial system to criminal exploitation. There were approximately 76,000 additional contraventions which expanded on the original statement of claim. Next slide, please. And as you'll see, in summary, Westpac admitted to significant failures with respect to record keeping, and in particular, failing to pass on information relating to the origin of some of these international funds transfers, including the source of funds to other banks in the transfer chain, which led to those banks not being able to manage their own money laundering transfer risk in the context of correspondent banking. And that completes my slides. Thank you very much.
Thank you so much, Dennis. We're going to keep things moving now. We're going to turn things over to slide number 43 and over to our next speaker before hopefully we'll be able to get to some audience questions as well. But for now, slide number 43 is on screen, and without further ado, Eric, the floor is yours. Over to you.
Thanks so much, Andy. I appreciate it. I'm going to talk about AML obligations for U.S. broker-dealers. I certainly hope that at least much of what we discuss will be directly relevant for those of you who operate within that space, but it may also have some value for those of you who work or do work for other types of companies or for companies in other jurisdictions, as it may give you some insights into what animates the actions, the decisions, the policies of U.S. broker-dealers with which you or your companies may do business. The specific topics I'll discuss are some very brief background regarding the broker-dealer SAR rule, recent guidance from the U.S. Treasury Department's Financial Crimes Enforcement Network, or FinCEN, regarding the customer due diligence requirements. And then I'll talk about a category of transactions that's been drawing regulators particular scrutiny, that being deposits and sales of low-price securities. And finally, I'll go through probably very quickly some findings and sanctions from a sample of enforcement actions during the past few months. If we can go to the next slide, please. The broker-dealer SAR rule essentially requires broker-dealers to file reports with FinCEN of any suspicious transactions. Next slide, please. And those are defined as those involving $5,000 or more, where the broker-dealer knows, suspects, or has reason to suspect that they involve funds derived from illegal activity or structuring, or if they have no business or apparent lawful purpose, or if they're used to facilitate criminal activity. Next slide, please. Both of the two most prominent regulators of U.S. broker-dealers in the U.S. have rules giving themselves what they regard as authority to help enforce the broker-dealer SAR rule and other AML requirements. The U.S. Securities and Exchange Commission, the SEC, has its Rule 17A8, which is laid out on the slide, and then the Financial Industry Regulatory Authority, or FINRA, which is the quasi-governmental self-regulatory organization of which most U.S. broker-dealers is a member, has Rule 3310, which requires its members, so most broker-dealers, to establish an anti-money laundering program to detect and cause the reporting of suspicious transactions and to achieve compliance with the Bank Secrecy Act and its implementing regulations. One requirement from those regulations is the customer due diligence rule. And that is a relatively recent rule. It requires financial institutions such as broker-dealers to verify the identities of customers, including significant owners of the customers that are entities. It requires them to create risk profiles of their customers and then finally to monitor and update customer information. Next slide, please. This past summer, FinCEN decided to issue guidance in response to questions the agency had apparently been receiving about how to go about meeting those customer due diligence requirements. One set of questions had to do with how to go about gathering the information in order to comply with those requirements. Financial institutions wondered, was there any particular information they should be gathering? Whether they should be searching news outlets for any information about the customers, and whether they should try to gather information on their customers for those who had their own underlying customers. And FinCEN basically said, "Hey, great questions. Would love to help you with them." And the answer is maybe. We're not saying the CDD rule does require any of those things, but we're not saying it doesn't either. It depends. So financial institutions moved on to ask about the risk profile aspect of the rule. Saying, is it, any particular methods that we should be using to go about doing that? And FinCEN said, not really. We're sure you'll be able to figure something out. The industry, wondered, can we at least assume that if a customer shows up on a government warning somewhere, that we can, certainly treat that customer as being a high risk when we do our risk profile for them? Now, even though the answer to that question is obviously yes, FinCEN wasn't quite ready to go that far out on a limb to say that either. Instead, just saying that the rule doesn't require you to categorize them that way, but again, not saying that you don't need to either. And then finally, with respect to the CDD rules monitoring and updating requirements, the industry wondered whether that should be done continuously. Should you be updating on a set schedule, or what? And once again, FinCEN basically said, you're on your own. Best of luck making the right decision. Needless to say, such what I would characterize as equivocation is not particularly helpful for people trying to advise their firms on how to comply with the CDD rule, or for that matter, people trying to address the topic in a webinar. But nevertheless, my own suggestions would be to, certainly perform the media searches, to collect whatever information you can reasonably collect about the customers, to establish a schedule for updating customer information every year or every 2 years, to put in procedures to make sure that that any significant changes or flags that come to the firm's attention during the interim are captured, and that whatever you do decide to do or not to do, that you document the reasons for that decision so that you're readily able to defend them later on if necessary. Next slide, please. I would also suggest that in creating, if we go to the next slide, please, thanks. In creating the risk profiles, financial institutions categorize any customer that significantly trades low-price securities as a high-risk customer. Low-price securities are also known as penny stocks, microcap stocks, LPS for short, and it generally refers to stocks with a market price of below $5 per share on the high end, all the way down into fractions of a penny. Those types of stocks have a well-earned reputation for being disproportionately associated with securities law violations, such as registration violations, securities frauds, market manipulation, trading on misrepresentations and omissions, as part of promotional campaigns to boost the price of a stock, insider trading, particularly with respect to control persons selling their shares without disclosing negative information about the issue that's non-public. The classic example is the pump and dump scheme, where you've got insiders who own large holdings in an LPS stock. They may use manipulative trading or false promotional campaigns to pump up the price of the security before then dumping it on the public by selling it at higher prices to unsuspecting people who don't sort of know the truth about the companies. Next slide, please. There are a number of well-recognized red flags for pump and dump schemes and other illegal activity involving low-price securities, sales without purchases, where they just deposit the shares and then sell them, high volumes during a particular period of time relative to the average daily volume for the securities. They may go days or weeks without hardly any activity in the market, and then all of a sudden a great deal of frenzied activity. Sales during promotions, as I mentioned, if there's negative news or regulatory histories of either the issuer or of the customer, where after making the sales, the customer immediately wires the funds out of the account instead of keeping them there, maybe investing them in something else. Instead just get rid of them and take them, pocket them, so to speak. The issuers will often not have many revenues or operations themselves. They're often shell companies. And many times they'll be changing their name or the business line that they're in, either to hide the poor reputation that they've developed or because they really don't have a business. Next slide, please. So that list of red flags for potentially suspicious LPS transactions has emerged over the years through many enforcement actions and pronouncements from securities regulators. What's new is that last month, one of those regulators published guidance relating to a particular venue in which LPS transactions had received less attention. And specifically, the staff of the SEC's Division of Trading and Markets put out a bulletin on the risks associated with omnibus accounts transacting in low-price securities. Now, an omnibus account is an account that aggregates the accounts of undisclosed underlying customers of the account holder. It's a type of securities clearing arrangement where a bank or other financial institution opens an account with a large broker-dealer that the first firm then uses to conduct that account, to conduct trades and hold securities positions of the first firm's customers in that large account. And then the names and details of those underlying customers are not disclosed to the large broker-dealer that's actually holding the positions. Instead, that broker-dealer just aggregates all the positions together on its books and treats them as all belonging to the first firm, to the bank or the financial institution. The staff bulletin points out, probably correctly, that there are heightened risks associated with LPS transactions affected through omnibus accounts, particularly those accounts that are maintained for foreign financial institutions or FFIs. And the reason is that the anonymity of the underlying customers can facilitate the very dangers you have with LPS, right? The non-exempt securities offerings, where the broker-dealer, unregistered offerings, where the broker-dealer, may not, wouldn't know that whether the owner is a control person or has satisfied exemptions from securities registration requirements. Fraudulent stock promotion. Again, the BD wouldn't know whether the customer selling low-price security is simultaneously touting the issuer to the public. Or manipulative trading. The broker-dealer wouldn't know whether the customer was trading the stock, actively with themselves in an effort to make it look like there was more activity than was actually the case. Next slide, please. After pointing out those risks, the staff bulletin offers suggestions for what the broker-dealer can do in light of those risks. In particular, the trading and market staff offers suggestions for how to manage the risks and for what to do if the broker-dealer cannot manage the risks. In terms of managing the risks, the bulletin suggests that broker-dealers could consider obtaining information about the ultimate beneficial owners, in other words, the underlying customers of the bank or the financial or the FFI. Secondly, obtaining certifications from the FFIs regarding the owners. Or third, monitoring the transactions more closely, such as by adjusting risk parameters. Now, the first two of those suggestions are pretty radical, actually, because you've got to remember that the whole premise of an omnibus account is that the broker-dealer doesn't have the information about those ultimate owners. There's actually a different type of arrangement called a fully disclosed clearing arrangement, where the clearing firm, the large broker-dealer, does keep separate accounts on in the underlying customers' names on its books. But even in those situations, that clearing firm typically is not obligated to get information about the risk profile of those customers or to analyze information about those customers. So what the staff seems to be suggesting in the bulletin is that broker-dealers offering omnibus accounts should consider obtaining information that even the broker-dealers for fully disclosed clearing arrangements don't obtain and don't analyze. The third suggestion of increasing monitoring seems more practical and logical, but how might those alert thresholds be adjusted? The bulletin doesn't say. My own suggestion would be to make sure that they focus on some of the red flags that we just went through a couple of slides ago. The bulletin does offer suggestions for what broker-dealers can do if they feel they cannot manage the risks, including closing or refusing to open the omnibus account, restricting or rejecting LPS transactions by FFI's customers whose characteristics cannot be determined, and then filing SARs. Now, once again, these first two suggestions don't strike me as very practical. Omnibus accounts are typically very large, they're often quite lucrative, and the vast majority of the transactions in them will typically pose very low risk. Closing or refusing to open such an account is a very drastic step with significant business consequences. And my suspicion is that no one on this webinar would relish the prospect of trying to convince his or her business leaders to close or reject such an account. The second suggestion, may not be a whole lot better, considering that, just as we discussed, learning the characteristics of underlying customers is at odds with the fundamental nature of the omnibus account relationship. Because you got to remember, the FFI's relationship with those customers may be the FFI's most valuable asset, right? They might be very reluctant to share information about them. So that leaves filing SARs. Now that suggestion seems more reasonable, and it is consistent with the obligations that a broker-dealer already has. You do have to keep in mind that the lack of transparency, that's endemic to the omnibus account, could result in the need to file more SARs than might otherwise be the case, because it will be harder for the AML investigative staff of the broker-dealer to learn information that may put their suspicions or potential suspicions to rest. and of course, continuing to affect transactions after filing SAR after SAR carries its own risks. You can go to the next slide, please. Last month's staff bulletin is far from the only example of recent regulatory interest in low-price securities transactions from an AML standpoint. This summer, the SEC reached a settlement with Interactive Brokers in which the agency found a myriad of AML violations in terms of how the firm monitored, investigated, and reported suspicious transactions involving low-price securities, and the firm, as a result, consented to an $11.5 million civil penalty. Next slide, please. And now this is actually not a duplicate slide, although it might look like it at first glance. But what happened here is on the same day, FINRA fined Interactive Brokers as well. And I'm sure we've all had our share of bad days. Hopefully none of us has had one in which we've been fined a total of $26.5 million. Here, the conduct that was at issue was partly having to do with low-price securities, partly more generalized, and this was a $15 million fine on top of the $11.5 from the SEC. And I guess one of the important things to understand about these two cases, is that Interactive Brokers is a legitimate, reputable broker-dealer. It's been around for more than 25 years. It's one of the U.S.'s leading online broker-dealers. It has a talented and dedicated legal and compliance staff. This firm did not initiate any violative transactions or recommend that its customers do so. And yet it got hit with more than $25 million in fines. And so the lesson, and this is one that you may want to share with your business colleagues, is that devoting insufficient attention or resources to AML compliance obligations can have significant financial consequences for even the most upstanding and well-meaning broker-dealers. And then just the next slide is an action which I won't discuss against Celadon Financial. It was fined $125,000 for AML failures in connection with low-price securities. And then the final slide on slide 55, Biltmore, also $125,000. Similar LPS violations. You can read more about it afterwards. The lower fines here are a reflection of the fact that Interactive Brokers has net capital of around $5.5 billion. These companies less than $2 million, and so actually as a percentage of net capital, the fines against them were bigger in some sense. Thanks very much for listening, and now I'll turn it back to Andy.
Thank you so much. Before we do get to some audience questions, I just wanted to give that third and that final secret word of the afternoon, where secret word number 3 is trading. That's TRADING. So trading is today's third and final secret word of the day. We've got a couple of questions here from our audience. And Tracy, this first one is for you, and it's just asking, what do you find are the most common areas that are often overlooked when it comes to setting up a risk management framework, and how could one maybe mitigate against some of those? Apologies. So the most common areas most overlooked when it comes to coming up with a risk management framework, and maybe is it an over-reliance on traditional methods? The author.
Yes, that's exactly where I was going to go with that. I think, over-reliance on only physical identity data in a world where we are transacting so much digitally, and there's so much exhaust there in terms of data signal that's out there to help you get your arms around that without disrupting the customer experience. No question, that's absolutely, to me, the most overlooked opportunity in the space.
Thank you so much. I want to try and squeeze in a couple more questions before we start to wrap things up. Dennis, this question dropped in during your segment. It just asks, COVID-19 seems to be the main focus of a lot of what you discussed or what you've found there. Do you find that that's indicative of high-profile, sort of newsworthy global events, or is it mainly because of the nature of the pandemic and the finances surrounding it that you think is the main driver for COVID-19 being a major theme in the types of crime that you're witnessing?
Good question. I think it's probably a little bit of both. I think dealing with the second part of the question, it is the case that because of the significant fiscal stimulus by most states across the globe in order to assist the economies over the COVID period, it was almost inevitable that criminal groups and transnational criminal groups would seek to take advantage of that enormous money flow. And so a lot of the crime typologies seem to be related to frauds concerning that. In terms of its prominence in the typologies for 2020 as published by the APG, I think it's also the case that it naturally has attracted attention because it's a unique moment, at least in the last century or so, where we have an opportunity to look at the way in which crime operates during a pandemic period. So in and of itself, that's quite newsworthy and probably has provided a unique opportunity to those involved in the study of anti-money laundering to examine how financial crime operates in very specific moments of human history, and we've just experienced one of those.
Thank you so much, Dennis. And Eric will close with this question here for yourself. For omnibus accounts held by an FFI, are the ultimate beneficial owners considered customers of the broker-dealer for CIP and CDD purposes?
No, they're not. For purposes of the customer identification program, the customer would be the FFI, the foreign financial institution, that's the direct holder of the omnibus account. Similarly, the BD's customer due diligence obligations include obtaining information about the beneficial owners of the FFI as the broker-dealer's direct customer, but not the identities of the ultimate underlying customers of that account. I guess I would just add that one of the main points of the staff bulletin is that although that's not necessary for CIP and CDD purposes, from a SAR filing standpoint, the broker-dealer nevertheless might need to obtain information about those underlying beneficial owners, those underlying customers of the FFI, in order to fulfill its SAR filing obligations. So technically not CDD or CIP, but nevertheless potentially important.
Thank you so much. And that's about all we've got time for this afternoon. Just before we wrap things up, I wanted to thank our speakers again for assistance in preparation for this afternoon's program. If you are applying for continuing education credit today, that survey is mandatory, serving as your proof of attendance required by your state bars or boards. So you'll need to enter the 3 secret words that were read out earlier. Now, if you do have any questions regarding that or any other question for us, you can always send us an email, info@theknowledgegroup.org. If you do have a question for one of our panelists that unfortunately we may not have had time for, you can always drop us an email, a contact request, or contact the speakers with the information found on screen and within your materials. Once again, that address, if you can't find those for whatever reason, info@theknowledgegroup.org. And ladies and gentlemen, that concludes this afternoon's webcast on AML and CTF, taking a look at some trends, developments, and enforcement actions to offer you a guide in 2021. Now, on behalf of Tracy, Dennis, Eric, and all of the team here at the Knowledge Group, we hope you've enjoyed this afternoon's program. And until next time, everyone, take care and bye for now.